All right, hi, and welcome back, Attorney Steve Vondran. Welcome to another exciting video. Today we are talking about the legal side of politics. I have a new little playlist for legal side of politics. More people have been asking me to interpret some of these things that are happening on the news, so-called news, or whatever you want to call it. Some people call it fake news, on and on and on. But this is the legal side of politics. Today we are talking about the contempt hearing, or excuse me, not the contempt hearings, the hearing into Corey Lewandowski, former campaign manager for now President Donald Trump. And the Democrat Party has come up with impeachment investigation hearings. It's not an actual impeachment. It's a investigation or a probe, as they call it, and into the Russian collusion, Russia interference with the 2016 election. So Corey Lewandowski is up on taking the hot seat, and I watch this briefly as a lawyer because if you're a new lawyer and you want to get some deposition skills, this is the place to go watch. I mean, these senators are smart. They're smart people. A lot of them are trial lawyers or ex-lawyers or whatever, but they know what they're doing, and you sometimes get someone like Corey Lewandowski who is being accused of stonewalling and not answering the questions and trying to be evasive or sparring, as they call it, sometimes sparring with the attorneys or the Congress men and women. So one of the channels I noticed in the break was talking about, they should hold him in congressional contempt and inherent contempt. So I didn't know what that was, and so I'm looking this up for the first time. And it's interesting. It says here, and this is from Wikipedia, thank you, under the Creative Commons share alike option, and appreciate that. We all love Wikipedia. Make sure to donate. Inherent contempt. This is what they want to one of the persons was saying should be charged with. Under this process, the procedure for holding a person in contempt involves only the chamber concerned. Then here we're talking about the House Judiciary Committee. It's a little committee of the House. Following a contempt citation, so the chairman, Nader chairman, could cite Lewandowski for contempt. And what happens is, this is kind of weird, person cited is arrested by the sergeant at arms for the House or the Senate, brought to the floor of the chamber, held to answer charges by their presiding officer, and then subjected to punishment as the chamber may dictate, usually imprisonment for punishment, imprisonment for coercion, or release from the contempt citation. And I found this here, concerned, I thought this was interesting, concerned with the time-consuming nature of a contempt proceeding. Obviously, you have to follow these steps, and the inability to extend punishment further than the session of the Congress concerned. Under Supreme Court rulings, Congress created a statutory process way back in 1857. That's interesting. While Congress retains its inherent contempt authority and may exercise it at any time, this inherent contempt process was last used by the Senate in 1934 in a Senate investigation of airlines and the U.S. Postmaster after a one-week trial on the Senate floor, presided over by Vice President John Nance Garner in his capacity as Senate President. William P. McCracken, Jr., a lawyer and former Assistant Secretary of Commerce for Aeronautics, who was charged with allowing clients to remove or rip up subpoenaed documents, was found guilty and sentenced to 10 days imprisonment. McCracken then filed a petition of habeas corpus, which is why am I being held, in federal courts to overturn his arrest, but after litigation, the Supreme Court ruled Congress had acted constitutionally and denied the petition in Journey versus McCracken. So I've got a nice video out there on the writ of certiorari if you want to learn more about Supreme Court appeal. Presidential pardons appear not to apply to a civil contempt procedure such as the above. So if they were to cite him for inherent contempt, go through the statutory proceeding, the president could not pardon him. So that's interesting to know. According to this, which I find interesting since it is not an offense against the United States or the dignity of public authority. Statutory proceedings, I'm not going to read this for you, but if you're interested, just going to start it, but if you're interested, you can pause it and read it. But following a contempt citation, the presiding officer of the chamber, this is the procedure they have to follow. It's probably why they would never do it. It's a cumbersome process. And following a contempt, the presiding officer of the chambers is instructed to refer the matter to the U.S. Attorney for the District of Columbia, D.C. According to the law, it is the duty of the U.S. Attorney to refer the matter to a grand jury for action. This gets quite cumbersome here. However, while the law places the duty on the U.S. Attorney to impanel a grand jury for action, some proponents of the unitary, I'll let you read the rest there, but I just wanted to bring you this. I'm trying to make my videos shorter. People tell me, I love your videos. Can you just trim them down a bit? So I'm going to try to cut this one short. But this is Attorney Steve, general legal information only, not legal advice. Thought you would find it interesting. Corey Lewandowski, and are they really going to pull some inherent contempt and go through a statutory proceeding? You know more than most people do now. Most people on TV know. So there you go. Attorney Steve, keeping you informed, keeping you in the know. Knowledge is power. Don't forget it. Have a great day. I got to get back to work. We'll talk to you later.